both orders have been passed ex parte. The trial court may be directed to consider the application upon hearing me. That is my only grievance.
My lord, if
First
I'm-
application is for maintenance of 25,000 ex parte order has been passed. And the second application is attachment of salary has also been allowed without my presence. So my only prayer is that let my objections be considered and I may be heard.
Where is the order?
A2 for interim maintenance.
You are the
I am the respondent therein here.
husband.
Husband. Attachment of salary.
Where are you working?
Well, as I'm a scientist, this Honorable Court granted an interim stay of the impugned orders by directing me to pay monthly maintenance of 8,000 rupees. That I'll continue to pay if I am allowed to contest these applications.
So what is ordered now by the family court?
25,000 and the attachment of salary. Right, and this Honorable Court has granted an interim relief directing me to pay 8,000 per month.
But you are
Continue
paying.
to pay the until consideration of these.
But you are paying.
That I'm paying.
You paid the arrears as well?
Please. I
You
have paid the arrears as well.
Yes,
my
what
lord,
is-
if I may, my lord. My lord, the husband abandons the wife and the child, my lord. It's a girl child, today 11 years old, in 2019. He goes and files a divorce petition and withdraws it subsequently.
After your petition.
No, my lord. He goes, files it. Notice is sent to where the father resides. Father does not take the notice. It is returned. He goes before the Lok Adalat and says that it is settled and he withdraws the petition because of some jurisdictional issues. Soon after, my lord, he transfers his property that was standing in his name to the name of his father, gift deeds it. In fact, my lord, we have all documents to show that the funds to purchase the property came from the father of the wife. As soon as divorce petition is filed, withdrawn, he transfers the property. Now I file all the complaints, my lord, again, because he has abandoned me and the child. He leaves the house abruptly and goes away. Now, my lord, I filed it, after he files all this divorce petition, I file this restitution now. My lord, in the restitution on the first date, court considering the fact that I have a daughter, I do not have my own source of income, I have to pay my rent, I have to take care of the child, passes an order, directing him to pay 25,000. My lord, the orders are quite clear, my lord. He appears before the court. It is not as if it was passed thereafter ex parte. For 1 year, he does not pay a single rupee. During the time of COVID, my lord, he is least concerned about the welfare of the wife, this child, a girl child, my lord. Least concerned. After 1 year, my lord, what led to the attachment of salary, my lord? It can be very well seen from the order sheet. After 1 year, since he had not paid a single rupee in maintenance, despite the order of the trial court, it is then he filed this application. Learned counsel for the respondent has filed objection to the main petition. In filing, counsel and also filed memo stating that the objection filed by the respondent to the main petition may be treated as objection to the IA under section 24 of the Hindu Marriage Act. Respondent and counsel submits that they are ready to amicably settle of this issue dispute and prays to refer the matter for mediation. Hence, the matter is referred to National Lok Adalat, issue notice to learned counsel for the petitioner. This was, my lord, just a dilatory tactics. So, my lord, soon after what we did, we filed an application for attachment because it had been more than a year. Next date, case called out before Lok Adalat, settlement not reported, hence before regular court. Learned counsel for the petitioner is present, respondent and his counsel are absent. Learned counsel for the petitioner has filed memo with office address of the respondent. Learned civil judge JMSU before whom this petition was presented has passed an order directing the respondent to pay a monthly maintenance of 25,000 per month till further orders. Learned counsel for the petitioner would submit that till date of respondent has not complied with the order. Therefore, learned counsel for the petitioner has filed application under so and so, so and so. Since he was not there, my lord, and is not adhering to the order passed, the court attached this as per under section 28, my lord. Now, my lord, he only says that it is an ex parte order, he was not heard. He does not indicate what is the infirmity in the order. My lord, this court reduced the maintenance from 25,000 to 8,000, my lord. That amount is not even sufficient for me to pay the house rent, my lord. Forget looking after myself or the daughter. From 2000, not even a single penny spent on the child's education. The entire petition, my lord, is filled with fallacies and nothing else. Misrepresentation of facts against the record, my lord. My lord, my only contention is that the interim order that reduced the thing may be vacated. The trial court may be, the issue of maintenance may be heard before the trial court. He has not even filed the affidavit, my lord, before the court, trial court, regarding his salary or anything. He, according to our knowledge, he's earning more than 2 lakhs today.
What are you doing?
My lord, he admits, I do not have a degree. She has done some correspondence in cosmetology. She's not working today. She's not working today, my lord. Everything is taken care by her parents until this date, who is a farmer.
What is the order?
My lord, he has received more than 30 lakhs from the father, my lord.
But my only submission is that let trial court consider all these facts. I may be permitted to file my affidavit as per Rajneesh's case. Let them also file.
My lord, we are
In
ready
a
to do that.
time-bound manner, it can be disposed of by the trial court.
There is a child also involved?
Yes, my lord.
How
The
old
girl
is-
child,
How old is the child?
11 years today, my.
Where are you working?
He's a
He's a
scientist.
scientist.
My lord, as per
Salary?
before 4 years, my lord, when this came to be filed, it was between 1.5 lakhs is as per our instructions. Now we are expecting it to be somewhere around 2 lakhs because he's a scientist there, my lord.
The party may be directed to file an affidavit as per Rajneesh's case. Within a time-bound manner, both IAs can be disposed of.
All right, work out. We'll send it back to the trial court, family court to decide the matter.
My lord, issue of interim maintenance, my lord.
You pay maintenance at,
No, I've been paying 8,000 regularly.
My lord,
Let
it is
tri-
not at
whatever
all
trial
sufficient, my
court-
lord.
you
She's,
pay 10,000 to the wife and 5,000 to your child. Work out.
Let that issue be decided by the trial court. my lord.
Yes, it will be decided.
my lord. Also, my lord, it may be increased to 20,000 at least, my lord, because there's rent, child, and also
Go
her.
and agitate, he has not filed anything. He has to get an opportunity to defend his case and say, you also go and say, what is the income? Nothing is available on record before the rural court, civil judge, is it?
Please.
Yes, one submission, my lord, only one. My lord,
Yes.
till now, my lord, the expenses of the child in so education is concerned, my lord. She's been paying, my lord. It may be made 20,000, my lord, so she can recover. He's not paid a single rupee, my lord.
Yes, paid 8,500, arrears, everything. What else you want?
My lord, 8,000 is for maintenance, my lord, which is not even sufficient to pay court house rent, my lord. The issue of paying
What is the
school
material?
fees, my lord, school fees.
Where you are staying, what is the material you have placed before the court? Has the court considered all this aspect?
Well, the court has considered the fact while passing the order that rent is of 9,000. All that is produced, my lord.
Let the trial court
This
consider. my lord.
petition is filed by the husband, challenging the order passed under section 24 of the Hindu Marriage Act. And consequently, another order passed by the same court on the application filed under section 28A of the Hindu Marriage Act for attachment of this salary of the petitioner husband. Trial court has not provided an opportunity to the petitioner while granting the interim order, and has also not considered the salary of the petitioner as well as any income of the respondent. It is further contended by learned counsel for the petitioner that as per the interim order passed by this court, he has been diligently paying rupees 8,000 per month to the respondent, along with the arrears to the respondent wife. It is contended further by the learned counsel that the matter was not adjudicated on the merits, as no material was placed by the respondent to prove the income of the petitioner, and neither did he participated in placing any material before the court to decide the aspect of interim maintenance to the respondent and the minor child. Therefore, he contends that the matter be decided afresh by the trial court by providing an opportunity to the petitioner to place all materials with regard to his income, assets and liabilities, and also the respondent be provided an opportunity to substantiate her rights and contentions over the issue of maintenance to herself and the minor child. Per contra, learned counsel representing the respondent wife vehemently contends that the petitioner has conveniently protracted the proceedings before the trial court, despite having participated in the proceedings, has not bothered to place material or objections to the application filed by the respondent wife. Thereby, he has not paid a single penny to the petitioner, to the respondent wife and the minor child. The trial court has ordered rupees 25,000 per month, which has not been complied with. And the order passed by this court, by an interim measure, would not be sufficient for maintenance of the minor child and the petitioner. Hence, he seeks to affirm the order and dismiss the petition of the petitioner.
If I may,
I have heard learned counsel for the petitioner and learned counsel for the respondent. Petitioner herein has not filed a statement of objections to the application filed by the respondent wife before the trial court. The parties have also not filed their assets and liabilities before the trial court for proper adjudication of the matter on the merits of the same. Nevertheless, as per the affidavit filed by the respondent wife, she has stated that she requires rupees 9,000 per month as rent, and that the minor daughter studying in a school, what class?
7th.
7th standard, and her educational expenses are to be met, which has become a financial constraint for the respondent wife. She has also stated that she is not working and earning any income, based on which the trial court has passed an order of rupees 25,000 per month as interim maintenance to the respondent wife and the minor child. The petitioner requires to be provided an opportunity to file his objections to the interim application for maintenance and address his arguments on the application. So also, similar opportunity requires to be provided to the respondent wife to place any such material with regard to proof of income of the petitioner herein and her financial constraint other than the maintenance, including education and other miscellaneous expenditures. Both the parties are hereby directed to file their assets and liabilities by way of an affidavit before the trial court. Full stop. The trial court shall, upon filing the assets and liabilities by both the parties, namely the petitioner and respondent, provide an opportunity of hearing to both the parties and decide the matter expeditiously with regard to the application and within 1 month from the date of receipt of copy of the order. It is made clear that this court has not expressed any opinion on the merits of the matter. The orders passed on 23/12/2020 upon the application filed under Section 28A of the Hindu Marriage Act is hereby set aside. Full stop. It is made clear that if the petitioner does not comply with the order passed herein today with regard to maintenance, interim maintenance amount of rupees 15,000 per month to the respondent wife and the minor child, the respondent would be at liberty to execute the order in the manner known to law.
My lords, one clarification. My lord, the interim maintenance now which has been enhanced to 15,000, is he liable to pay from the date of this order or the order of the first order of the trial court?
No, this order. Already it is mentioned from when it is to be paid. The trial court has mentioned from when it has to be paid.
From the date of this,
The date of the order, itself.
from the date of application.
1,000 per
From the
month,
date of the
And-
petition.
from the date of petition.
That is.
Yes, date.